A woman stands at the threshold of her father's house. The sun hasn't risen yet. She can smell the incense from the courtyard, hear the rustle of her wedding garments. In her hand, a small clay seal, her father's mark. By nightfall, it will be replaced. She doesn't know that this seal, this moment, represents the last hour she will exist as a legal person. In 40 minutes, she will become property, not metaphorically, legally. This is the story history tried to erase with bureaucracy. Now, let's go back to the beginning. If you're interested in stories about the mechanics hidden in historical records, consider subscribing. 4,000 years ago, in the fertile river valleys where civilization first took root, lawmakers faced a problem. Not a military problem, not a famine, a problem of order. Women could own land. Women could testify. Women could refuse. And to the architects of early legal systems, this represented chaos that needed correction. The solution wasn't violence. It was paperwork. In ancient Mesopotamia, around 1750 BCE, the Code of Hammurabi was carved into black diorite. 282 laws, 43 of them concerned women, not to protect them, to define the boundaries of their existence. Law 128 stated clearly, if a man takes a wife and does not draw up a contract with her, that woman is not a wife. Marriage wasn't a bond. It was a transfer of legal custody, documented like the sale of livestock. The woman ceased to exist as an independent entity the moment the contract was signed. Yet here's what the law didn't say explicitly. It didn't need to. Law 141 addressed what happened if a wife wanted to leave. If a woman hates her husband and says, "You shall not have me," her case shall be investigated. If she has been careful and without fault, but her husband has been going out and greatly belittling her, that woman has no blame. She shall take her dowry and go back to her father's house. It sounds almost fair, until you read the next line. If she has not been careful, but has been going out, ruining her house and belittling her husband, they shall throw that woman into the water. Drowning. Not prison, not exile. Execution by drowning for the crime of leaving. Archaeological excavations near Babylon uncovered clay tablets from the Old Babylonian period. Among them, divorce proceedings. One tablet, translation dated to 2015, records a woman named Iltani who sought to dissolve her marriage. The record is brief. It notes her husband's name, the magistrate's seal, and a single phrase. Case investigated. Woman at fault. Disposed of according to law. There is no record of Iltani after that line. The system worked because it didn't feel like oppression to those who administered it. It felt like order. The laws were public, carved in stone in the center of cities. Everyone could see them. Transparency, they believed, was justice. But transparency of injustice is still injustice, merely formalized. Ancient Rome refined this approach over centuries. Roman law, which would influence legal systems for millennia, introduced the concept of patria potestas, the power of the father. Under this doctrine, a father held absolute authority over his household. His children, his slaves, his wife. All were under his potestas, his power. A woman never aged out of this custody. If her father died, it transferred to her nearest male relative. If she married, it transferred to her husband. She was always owned. Still, Roman law was more sophisticated than crude ownership. It created categories. A woman could be sui juris, independent, if she had no living male relatives. But even then, she required a tutor, a male guardian, to conduct legal affairs. The law explained this necessity in measured terms. Seneca, the Stoic philosopher, wrote approvingly of these restrictions. His reasoning was clinical. The female sex is weak in judgment and has need of a stronger hand to guide it. Not cruelty, guidance. That's how it was framed. The 12 Tables, Rome's earliest written legal code from 450 BCE, were even more explicit. Table 5, concerning inheritance and guardianship, contained a provision that later scholars would debate for centuries. Women, even when they have attained their majority, shall remain in guardianship, except vestal virgins. The exception is telling. The only women granted legal autonomy were those who had renounced sexuality, family, and normal social life entirely. 30 years of virginal service to the goddess Vesta bought you the right to sign your own contracts. For everyone else, perpetual childhood. Records from the Roman Forum include thousands of legal transactions, purchase agreements, property transfers, court testimonies. In archives examined by historians in the 2010s, researchers found a pattern. In cases where women appeared as parties, there's almost always a second name beside theirs. The guardian, the translator of female will into legal reality. Without him, her signature meant nothing. One papyrus from Egypt under Roman rule, dated to 127 CE, records a property dispute. A woman named Thermuthis sought to reclaim land stolen by her brother-in-law after her husband's death. The document is remarkable for what it reveals about procedure. Thermuthis could not bring the case herself. Her guardian, a man named Serapion, had to file on her behalf. The case took 3 years. The archives show Serapion died midway through. The proceedings halted until Thermuthis could secure another guardian. The land was lost. The law protected her, theoretically, but the procedure was the punishment. Medieval Europe inherited this framework and baptized it. Canon law, the legal system of the Catholic Church, became the blueprint for marriage and family law across Christendom. And canon law had very specific ideas about women. The Decretum Gratiani, compiled around 1140, was the most influential legal text of the Middle Ages outside the Bible itself. It synthesized centuries of church rulings into a coherent system. Distinctio 23 addressed the nature of marriage. It affirmed that marriage required consent from both parties. This was progressive for its time. Many legal systems didn't require the woman's consent at all. However, Causa 33 clarified what consent meant in practice. If a father gave his daughter in marriage, her consent was assumed unless she actively resisted. Silence was agreement, and resistance had to be absolute, public, witnessed, and sustained. A moment of hesitation erased any prior objection. The burden of proof was reversed. She had to prove she said no loudly enough, consistently enough, before enough witnesses. Otherwise, the marriage stood. Church courts across Europe processed thousands of marriage disputes each year. Historians examining diocesan records from 13th century England found a pattern. Women who challenged marriages faced a standard set of questions. Did you resist? How? Who witnessed it? Why didn't you resist more? The interrogation itself became a mechanism of compliance. One case from the Diocese of Canterbury in 1292 involved a girl named Marjorie. She was 14. Her father had arranged her marriage to a wool merchant. Marjorie told the court she had been forced. The merchant testified she had been quiet during the ceremony. Her father confirmed she had not objected. The priest said she had repeated the vows. The court ruled the marriage valid. The ledger shows her name one final time, then nothing. The ink continues on the next page with other cases, other names. Marjorie's story simply stops. The machinery of law didn't need to be cruel. It just needed to be thorough. But the most insidious mechanism wasn't in marriage law. It was in property law. Medieval English common law developed the doctrine of coverture. The word comes from the Norman French, meaning covered. When a woman married, her legal identity was covered by her husband's. She became femme covert. She could not own property, could not sign contracts, could not sue or be sued, could not keep her own wages. William Blackstone, the great legal scholar, explained it in his 1765 commentaries on the laws of England. By marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband. Suspended. Not limited. Suspended. She ceased to exist. Court records from 18th century England are filled with the consequences. Women couldn't leave abusive marriages because they had no money. It was legally his. They couldn't flee with their children because the children were legally his property. They couldn't sign a lease because their signature had no force. They existed in a state of legal non-being. One case from 1765 involved a woman named Elizabeth Canning. She had inherited a small estate from her uncle. Within a year of her marriage, her husband sold the property, spent the proceeds, and left her destitute. She sued for the recovery of her inheritance. The court ruled against her. The sale was legal. The property had been his the moment they married. She had no claim to her own inheritance. The judge wrote in his opinion, "The law has placed the wife's property under the husband's control for the preservation of marital harmony. To allow her to reclaim it would be to sow discord in the marriage." She had lost everything, but the law called it harmony. Wait. Stop for a moment. Let the weight of that settle. These weren't medieval superstitions. These were legal principles crafted by educated men, debated by scholars, applied by judges who believed they were upholding civilization. The cruelty wasn't a bug. It was the system working as designed. Now think about what that means. Every mechanism of oppression we've described, the guardianship requirements, the consent doctrines, the property transfers, the suspension of legal existence, wasn't hidden. It was public, taught in universities, defended in treatises, enforced in courts. And the people who administered it didn't see themselves as monsters. They saw themselves as upholders of order. The archives show us how it felt to be caught in this system. Letters survive, diaries, petitions. In the British Library, there's a petition from 1702, written by a woman whose name has been damaged in the manuscript. Historians refer to her as Mrs. D. She had fled an abusive husband. She petitioned the court for permission to live separately and keep a portion of her own earnings to survive. The petition is 12 pages long. It details beatings, starvation, threats. She provides witness statements from neighbors. She cites legal precedent. She begs in careful legal language for the right to exist independently. In the margin of the final page, in different handwriting, there's a note from the magistrate. Petition denied. Wife's duty is to return to husband. No legal grounds for separation, absent proven adultery on his part. She had proven violence. But violence wasn't grounds for separation. Only his adultery was. Not hers. That would be immediate grounds for him to divorce her. His. There is no record of what happened to Mrs. D after the petition was denied. The system persisted because it reinforced itself. Lawyers learned it in training. Judges applied it in courts. Priests preached it from pulpits. And women internalized it. That's the most devastating part. When oppression is lawful, it becomes normal. When it's normal, it becomes invisible. Documents from colonial America show the same patterns replicating in the New World. The Massachusetts Bay Colony, founded by religious reformers who had fled persecution, immediately enshrined coverture in their legal code. A woman could not testify in court without her husband's permission, could not make a will without his consent, could not refuse sexual relations. Rape within marriage was legally impossible because she had consented to perpetual sexual availability when she said, "I do." Court records from Salem, Massachusetts in the 1670s include a case that illustrates the logic. A woman named Sarah Bishop accused her husband of beating her so severely she lost hearing in one ear. The magistrate questioned her at length. Then he questioned the husband. The husband admitted the beating, but explained she had disobeyed him. The magistrate ruled no crime had been committed. A husband had the legal right to discipline his wife with reasonable force. Sarah asked what would be considered unreasonable force. The magistrate's reply is preserved in the court record. That which causes death or permanent disfigurement. She had lost hearing in one ear. That apparently didn't qualify. But the law also created absurd paradoxes that revealed its own contradictions. If a woman committed a crime in her husband's presence, she could not be prosecuted. The law assumed she was acting under his command. Thus, she bore no legal responsibility. She had no legal autonomy, so she had no legal guilt. But if he was absent, she was fully culpable. The law simultaneously claimed she was incapable of independent judgment and held her criminally responsible depending on whether her husband was in the room. This contradiction didn't go unnoticed. Legal scholars at the time debated these paradoxes in academic journals, not to reform the system, to refine it, to make the logic more consistent while preserving the outcome. The archives reveal another mechanism that's easy to miss: wills. In societies where women couldn't own property during marriage, the only moment a woman might control assets was in widowhood. But even then, the law intervened. Many legal systems imposed dower rights. A widow was entitled to 1/3 of her husband's estate. Sounds protective, but it meant she got 1/3. The other 2/3 went to his heirs, often his sons. Her own children, if she had daughters, got nothing unless their father had specifically willed it, and fathers often didn't. Because daughters would lose control of any inheritance the moment they married anyway. Why bequeath property to someone who legally couldn't keep it? Estate records from 18th century Virginia show this pattern clearly. Wealthy planters left detailed wills. Sons received land, slaves, money. Daughters received household items, personal effects, or small cash amounts meant for dowries. The disparity wasn't accident. It was rational allocation under a legal system where giving a daughter property was effectively giving it to her future husband. One will from 1748 is particularly stark. A tobacco planter named Thomas Wickham left his son 800 acres and 23 slaves. His daughter received 1 bed, 1 table, 6 chairs, and 50 pounds sterling to be used for her wedding expenses. The will explicitly stated, "I leave my daughter little as I trust her husband will provide for her adequately." He died when she was 9 years old. She married at 16. There is no record of what her husband provided, but the law ensured she couldn't inherit what her father could have given her. The most chilling aspect is how the system trained women to police each other. Mothers taught daughters to accept it. Older women advised younger women to submit, not because they were collaborators, but because survival required compliance. Resistance was punished not just by law, but by social exile. A woman who challenged her husband, her father, her guardian, risked losing everything: her children, her home, her reputation, her community. And society called this stability. By the 19th century, resistance finally found organized voice. Early feminists like Mary Wollstonecraft attacked the absurdity of systems that treated adult women as legal infants. But the backlash came from unexpected places. Many women themselves opposed reform, having internalized the ideology that their dependence was protective, natural, even divinely ordained. The fight to dismantle coverture took decades. When England's first Married Women's Property Act passed in 1870, it granted women only the right to keep their own earnings. Not property, not inheritance, just wages. And even this modest change triggered fierce opposition. Lawyers warned it would destroy families. Clergy cited scripture. Legislators questioned whether women could handle such responsibility. 12 more years passed before English women gained the right to own property independent of their husbands. 43 years from the first reform attempt to partial legal autonomy. And even then, exceptions and restrictions would take another century to remove. Yet here's what's easy to forget. For most of recorded history, for thousands of years, the systems we've described weren't aberrations. They were normal, codified, defended by the most educated minds of their time, enforced by institutions that saw themselves as just. The archaeological and archival evidence is overwhelming. From Mesopotamian clay tablets to Roman papyri, from medieval court rolls to colonial American legal records, the pattern is consistent. Law was the instrument of control. Not violence, though violence was always available as enforcement, but law. Clean, rational, public law that everyone could read and therefore no one could claim ignorance of. The genius of using law was that it made oppression invisible. A woman beaten in the street is a victim. A woman whose legal identity is suspended by marriage certificate is simply married. One looks like violence, the other looks like paperwork. But paperwork can be more violent than fists, because paperwork is permanent, systematic, and enforced by the state. You can run from a violent man. You cannot run from a legal system that defines you as non-existent. The records show us the mechanisms, but they also show us the gaps. Pages torn out, names scratched away, whole sections of court records marked "case dismissed" with no explanation. Women who appear in one document and vanish from the next. The archives are full of absences that speak louder than what's written. There's a margin note in a 14th century English court record, barely legible. A case about a disputed inheritance. A widow was contesting her late husband's will. The case dragged on for years. Then, on the final page, someone, a clerk, a judge, we don't know, wrote in tiny script along the edge, "Woman withdrawn, matter resolved." No details, no outcome, just resolved. Historians have theories about what that means. None of them are comforting. Modern excavations have uncovered more. In 2019, archaeologists working in London found a medieval cemetery that had been forgotten. Beneath a construction site, they found over 200 skeletons. Most were women. Many showed signs of malnutrition, repeated fractures, and injuries consistent with sustained abuse. The cemetery wasn't marked on any map. There was no church associated with it. It was a burial ground for women who had died outside the bounds of community protection. The lead archaeologist noted in the published report, these women existed in the gaps of legal systems, too poor for courts, too isolated for protection, too invisible for record-keeping. They had lived in a world with laws about women's rights, but the laws hadn't helped them, because laws protect those who can access them. And to access law, you need resources, documentation, witnesses, and someone willing to represent you. These women had none of that. They were buried without markers, without names, in a cemetery that was deliberately forgotten. That's what legal erasure looks like when you dig it up. Today, we look back at these systems with horror. We tell ourselves we've progressed, and in many ways we have. But the mechanisms remain recognizable. Administrative barriers that look neutral but function as gatekeeping. Processes so complex they become inaccessible. rights that exist on paper but require resources to enforce, laws that protect in theory but abandon in practice. The clay tablets of Babylon are in museums now. The Roman papyri are digitized. The medieval court rolls are archived. We study them as history. But history isn't past if the patterns persist. The woman at the threshold, the one we met at the beginning, with her father's seal in her hand, she's a composite, built from dozens of records. But she's also real in the sense that thousands of women stood at that threshold, knowing what came next, having no legal means to refuse it. Archaeologists have found hundreds of these personal seals in excavations across the ancient world. Small clay objects people use to mark property, authenticate identity, sign contracts. They're cataloged in museums now. But women's seals are conspicuously rare. Not because women didn't exist, because women's seals had no legal weight. They weren't made, or weren't kept, or weren't preserved as significant. The absence in the archaeological record mirrors the absence in the legal record. This is how systems erase people. Not dramatically, but bureaucratically, by making them legally irrelevant, which over centuries makes them historically invisible. The question we're left with isn't just historical, it's immediate. When we create systems today, legal, corporate, social, how do we ensure we're not just replicating these patterns with better language? How do we tell the difference between protection and control, between structure and erasure? The archives don't answer that question. They just remind us it needs to be asked. Because every system that oppressed women in history claimed it was doing something else, providing order, ensuring stability, protecting families. The stated purpose was never oppression. It was always something that sounded reasonable. And that's the part that should keep us awake at night. Not that people in the past were uniquely cruel, but that they believed they were being fair, using the tools of law and reason to build just societies. And they were wrong. Systematically, devastatingly wrong. Which raises the uncomfortable question, what are we systematically wrong about right now?
The tablets don't tell us that. The papyri don't tell us that. The court records, the petitions, the margin notes, they just show us the machinery after it's been running long enough to leave marks. By then, generations have already been fed into it. So we're left with fragments, clay seals that meant nothing, petitions denied, names scratched out, graves without markers, and the faint, terrible suspicion that invisibility was always the point. Because if you can make someone disappear in law, eventually they disappear from history. And if they disappear from history, it's as if they never resisted at all. But they did resist. The evidence is in the margins, the scratched out names, the petitions that shouldn't exist but do, the graves that were found because someone went looking. Resistance leaves traces, even when it's erased. That's what the archives teach us. Not that the systems were inevitable, but that they were contested. Every step of the way, they were contested. And the fact that we have to dig through layers of bureaucratic deletion to find that resistance tells us everything about who controlled the pen. The woman at the threshold is still standing there, in every record we have, waiting for sunrise, holding a seal that won't matter by sunset. And history, which could have preserved her name, preserved the law that erased it instead. That choice, what to remember and what to forget, wasn't neutral. It was never neutral. It was a choice made by people who held the clay tablets, the papyrus scrolls, the court ledgers. People who decided what mattered enough to record. And they recorded law. They recorded property. They recorded transfers of custody. They didn't record her name.